My own remarks this morning concern constitutions generally and their relation to the rule of law. Let me say again how amazed, humbled, and grateful I consider myself to be a small part of this historic conference. Although I cannot claim to be an expert on the UAE Constitution, I appreciate all that we have to celebrate on its Golden Jubilee. As someone who has been privileged to live in the UAE for the past 8 years, I can attest personally that there is much to admire about this country. Indeed, every day that I've been here at NYU Abu Dhabi, I've felt myself tremendously blessed. To be sure, the prosperity, amity, friendliness, and benevolence that continues to be present for so many in this country derives in no small part from its constitutional order. I have a PowerPoint, which I hope we're going to get up here on the screen. Thank you. So first, a kind of prolegomena. I want to talk about the relation between the Constitution and the rule of law. The relation between a state's constitution and the rule of law is a complex one. It's the wrong slide. There we are. Yeah. The relationship between a state's constitution and the rule of law is a complex one, not susceptible to a comprehensive analysis in these introductory musings. However, I would like to start with a few brief observations. The Constitution and the rule of law are, first, distinct but related. One of the things that struck me most about His Excellency Zaki Nusseibeh's remarks was his description of the fervor and enthusiasm among the leaders and the population for the constitutional order. And indeed, in a sense, the Constitution represents this fervor and enthusiasm itself as a document. But at the same time, as he pointed out, the document itself is in part the rule of law, and it sets the foundation for the operation of the rule of law in the state's jurisdiction. The rule of law is derived in this sense from the Constitution, but is much larger than the Constitution itself, for it encompasses all those laws, regulations, and policies that the government elects to implement. So the Constitution and the rule of law are distinct but related. They are mutually reinforcing. The Constitution gives rise to the rule of law and is in part the rule of law. The rule of law bolsters the Constitution. And finally, the relation between the Constitution and the rule of law is essential to respect for human dignity, liberty, equality, human rights, and the common good. The idealism and hope of a state's constitutional order serve as the foundation for the realization of the peace, security, autonomy, participation, and flourishing eudaimonia of the citizens, which depends in no small part on the rule of law. So we might ask ourselves, what is the rule of law? This question applies to all states with modern constitutions, such as the one that we celebrate today. The UAE Constitution is of particular importance due to the prominence of the country in the Middle East and internationally. Moreover, the Constitution, now 50 years old, serves as a model for nations who seek to adopt a modern secular constitutional order. Without intending to be exhaustive of the meaning of the rule of law as a pragmatic vehicle to realize the constitutional vision, I pose three sub-questions in answer to the larger question, what is the rule of law? First, I'll speak about the basic meaning of the rule of law. Second, I'll speak about procedural fairness and the rule of law. And then third, I'll speak about substantive aspects and the rule of law. So the basic meaning of the rule of law. In its most basic sense, the rule of law means rule by laws and not by arbitrary authority. One of the primary purposes of a written modern constitution is to fulfill this basic meaning of the rule of law. In the noble words of Cicero, legum servi sumus, ut libere esse, we are subject to the law in order to be free. As F.A. Hayek put it, the rule of law, in its basic sense, means that the government, in all of its actions, is bound by rules fixed and announced beforehand, rules which make it possible to foresee with fair certainty how the authority will use its coercive powers in given circumstances and to plan one's individual affairs on the basis of this knowledge. The rule of law requires that people know the law. The rule of law requires that people can predict the outcome of their behaviors measured against this rule. And the rule of law requires that people know how the state will exercise its coercive power in its basic meaning. However, Joseph Raz has pointed out that the basic meaning of the rule of law does not guarantee that law will be good and just. In its basic meaning, rule by law can be tyrannical and oppressive, just as it can be respectful and freeing. So that brings us to the second possible answer to the question, what is the rule of law? We have the first answer. It simply means rule by law. Now I'll speak about procedural fairness and the rule of law. Lon Fuller identified 8 procedural requirements necessary to the rule of law. Law must be, 1, general and not ad hoc. 2, publicized. 3, prospective and not retroactive. 4, clear. 5, logical. 6, capable of obedience in practice. 7, stable and not subject to too frequent change. And 8, administered in a way that is congruent with the rule as announced. For Fuller, these procedural requirements are essential to answering the question, what does the rule of law mean? His procedural requirements seem also to assume features such as the independence of the judiciary, the principles of natural justice, access to the courts, and the effective administration of the law and justice by the courts, as well as by those who exercise executive and administrative power. Again, the modern Constitution, with its separation of powers, legislative, executive, and judicial, is designed to afford procedural fairness as an aspect of the rule of law. So that brings me now to the third part of the answer I'm proposing to the question, what is the rule of law? And this is substantive aspects of the rule of law. Jürgen Habermas asks, is it possible that law which meets the requirements for procedural legality, it fulfills what Fuller requires, is it possible that this law might be adopted in a democratic process that nonetheless denies fundamental human rights or significantly diminishes the common good, or does both? Habermas's question is a general question directed to all constitutional systems of government about the so-called substantive aspects of the rule of law. This approach to the rule of law holds that fair procedure alone is inadequate. It proffers that the rule of law also requires certain substantive guarantees, such as fundamental justice, human rights, and the common good. And so, in a sense, the basic meaning of the rule of law can be further enhanced by procedural justice and then by substantive justice. As I said at the outset, this is not intended as an exhaustive answer to the question, what is the rule of law? But it is an answer, I think, that gives us a good starting point. In conclusion, no country enjoys either a perfect constitution or rule of law. Nonetheless, a state's constitution affirms our faith in humanity, in justice, in reason, and in goodwill. It is the hope for the security and well-being of the nation and its citizens. The idealism and hope that underpin the constitutional order are in no small part realized through the rule of law. As we gather to celebrate the 50th anniversary of the UAE Constitution at this conference, by discussing its past, present, and future, we also honor the basic procedural and substantive guarantees of the rule of law. Thank you.